U.S. in particular. I thought that was quite a stark observation that in U.S. you have less than 5% of cases going to adjudication, and most to ADR, and yet it's quite the reverse in Europe. And I was just wondering whether that's a result of the fact that most of Europe happens to be civil law as opposed to common law. But I guess that's not the answer, because Italy, you're demonstrating towards Italy has success, and of course Turkey, or Turkey, I should say. Turkey also is a civil law system, but it seems to have managed to bring in ADR quite successfully. So it may not be related to just the civil and common law distinction, and maybe there are just an attitude of culture and decision to sort of allow ADR to emerge. And in the previous session, Professor Nuria, you will be familiar with this. We had a presentation that, what are the Islamic values relating to ADR, and of course the preferable route always in Islamic law is to go for compromise and try and settle disputes outside of court. So I think it'd be interesting to hear from you later whether that cultural pool or depth into which you could draw has been a factor in the success in the Turkish model. We now have online our speakers, panelists for the next session, and I've introduced you all in your absence for the sake of efficiency. And in this session, we're looking at experience of users and lessons learned and best practices from a user perspective. So I'll first call on the Honorable Chief Justice Anwarul Haq Sahab to please give his remarks. Over to you, Anwarul Haq Sahab. Anwarul Haq Sahab, are you there? We can see your name on the screen, but I can't see if your camera's on. So may I suggest that while we wait for Anwarul Haq Sahab to come online, if I can turn to the Honorable just retired Rebecca Westerfield, if you could share your remarks with us. Over to you, Rebecca. Thank you.
Thank you. Thank you so much. And from San Francisco, good morning to everyone. We have a bit of a fog here, but I hope the fog in my brain has lifted with the coffee that I just drank. But thank you so much for all of your willingness to listen to our comments today. It's very difficult to follow the previous speakers because they're so thorough and there is so much material in there. So I think I'm just going to come at this from a practitioner's point of view, that is as a full-time neutral. I am a founding member of JAMS, the Judicial Arbitration Mediation Services. We're the largest for-profit organization in the world providing ADR services. I do both mediation and arbitration. And I want to really congratulate ICADRP for putting this program together and for this launch. I had the pleasure of meeting Nudrat while she was a Weinstein Fellow. And you have quite a gift there in Pakistan with her participation and determination and her colleagues' determination to make sure that ADR gets off the ground in Pakistan and grows. I'm not going to get too much into the benefits of ADR. Adi already addressed that issue. I mean, obviously, choice of process, choice of neutral is key, control of the process, efficiencies, time savings, and so forth. I do want to emphasize one thing, and that is that ADR, Alternative Dispute Resolution, is simply an alternative. It is never and should never be a substitute in any way for our public courts or respect for our public courts. We need to work together as we have actually in the United States and complement one another. So I think that's a very, very important point. I do both mediation and arbitration, as I think I mentioned, but I never do it in the same case. I do think they are very, very separate processes. You can have processes where the attorneys and parties may agree that they want to have a MEDAR, mediation arbitration process. My personal view is the better practice is it should not be the same neutral who does that. 30 years ago when I became a founding member of JANS, people were still confusing mediation and arbitration. They did not really appreciate the difference between the two. And that was a very important part of what we did, was to try to educate the legal community about the difference. In arbitration, obviously the arbitrator is issuing a judgment, and in mediation it's a voluntary resolution through the facilitation by the mediator. But people were also confusing mediation with meditation. So I think it shows you how far we have come in actually establishing ADR, mediation and arbitration, as part of the court system. Audi has already shown some of the statistics, so I'm not going to get into all that. And I'm sure that our JANS management can produce those statistics, which will show you that we deal with billions, I'm not saying millions, but billions of dollars every year in terms of either awards or transferring monies through the mediation process. The ADR process has become embedded. It is part of the American litigation environment, as those statistics show us. In getting mediation and arbitration off the ground, it was imperative to have the buy-in, of course, of the bench. The bench and judges were very supportive of the projects because, of course, the caseload and the efficiencies, and by reducing caseloads, they could ensure actual access to justice. So they were very involved in the development of these multi-door courthouse processes and so on. And meanwhile, we in the private mediation world were trying to educate, of course, businesses and clients and insurance companies and corporations and the bar about the benefits of ADR. And what the attorneys learned was that they were getting greater client satisfaction at the end of a mediation process, rather than, hurrying, getting to the courthouse steps and then suddenly settling the case, which often happened on the courthouse steps. And they wanted a process. They began to understand that this process was a way in which they could develop better relationships with their clients, that they could serve their clients better. And they also began to understand that there was a very different set of skills that was necessary for mediation. You don't just obviously take a case immediately to mediation. A case has to be developed. You have to have enough information that it will be a worthwhile process. So the attorneys understood that, and we continue to give mediation advocacy training to lawyers as well. ADR now, alternative dispute resolution, of course, is a class that's offered in all of the law schools now for decades here in the United States. And that being said, as you all know, practice or theory, when it meets practice, sometimes is a little different. But at least those foundational concepts and skills have been developed very early on by our participating lawyers. So we engaged lots of bar leadership in supporting the development of ADR. I'm not going to talk too much about what's happened post-COVID, except to say that our caseload actually increased very significantly during the COVID period, because the courthouses were closed, but business needs to proceed. People need to get on with their life. They need to be free of the conflict and the emotional drain and the resource drain that conflict creates. So we saw quite an increase, and of course, I'm going to defer to my colleague Colin Rule there to talk more about technology and so forth, because he has always been on the cutting edge of technology. But here we are, again, 12 hours apart in terms of a time zone, but we're having a conversation. So thank you, Zoom. they kept they kept our process and our business going for sure. I think a couple of things I do want to leave you with thinking about, though, because I am really much more interested in your questions and hoping we can get to a Q&A period. And that is that I do think that it is incumbent upon us who have been involved in mediation and arbitration for so long to be very cognizant, very vigilant about the ethics and the ethical issues that come up, particularly in a process in private mediation that is not as transparent as the public courts. In the U.S., for the most part, it has been a very unregulated profession. Very few states require certification, certainly no federal requirement of any certification. In terms of the process itself, the legislatures have very few rules around how a mediation process is to proceed. Arbitration, very few rules around it, except for fundamental due process rules, so that, of course, any arbitration award would be enforceable and supported via the New York Convention, which I know those attorneys in the room who do international arbitration very well aware of the New York Convention. I would also like to remind you that there is a Singapore Convention regarding mediation enforcement, and I'm sure that you all have talked about that or will talk about that as well during the course of your program. So let me just leave on those remarks and express deep appreciation for being able to address you here today. And as the professor also acknowledged, my thoughts and prayers to those of you who are impacted or have family that have been impacted by the floods. We really wish you well. So thank you. I look forward to your questions.
Thank you, Judge Rebecca Westerfield, for that. And again, the U.S., I think, it has a lot of relevance, has perhaps the deepest experience in ADR. And I was wondering about your remark that it's been relatively unregulated in the U.S. That has its pros and cons. And one of the cons which comes to my mind in recent couple of years is that it allows employers to reach out-of-court settlements which could be quite abusive and against public policy. And similarly, if you look at the Weinstein case itself, you know, the sort of settlements he could enter into to cover his misdeeds. So there are perhaps public policy issues on what sort of regulations do we need so that we don't have use. I welcome your comment right now, Judges Westerfield. Go ahead.
Thank you. I appreciate it. First of all, let's be clear that the Weinstein case he's referring to as Harvey Weinstein has nothing to do with Danny Weinstein or the Weinstein Foundation. Secondly, that's a very good point, because actually as a result of that Weinstein case, the Harvey Weinstein Hollywood case, legislation has been passed in California where one cannot have confidentiality around those kinds of settlements. So the legislature did step in. So we are filling our way towards some regulation where there is a public interest at work. The other thing with regards to mandatory arbitration, that is consumer mandatory arbitration, such as in employment cases, that is, of course, highly controversial. And I would like to say that our company takes no view about that. We do not engage one way or the other whether we think mandatory arbitration is a good thing or a bad thing. But that is considered a consumer arbitration, and there is regulation around consumer arbitration. And all that regulation does is to make sure that the hallmarks of due process are available to the parties, especially the consumer employee, and I'm sure Colin Rule will talk more about this, to the consumers who are obviously in an adhesion contract situation. I mean, they don't get to negotiate the contract, and that's well known. Now, that being said, one of the things that the regulation or the statute requires, at least in California, is that the employer or the business that imposes the consumer arbitration provision in the contract has to pay for the arbitration. That creates a cost, by the way, which it actually incentivizes the employer, incentivizes the corporation, if you will, in many cases to actually settle the case as well, because it's an additional cost factor that they have to bear for the other side. So those are two ways of responding to those very important points. Thank you.
Thank you very much for that. I really appreciate your insights onto